morning, everyone, and welcome back to our weekly webinar series. Over to Anil sir, and he will take it forward.
Thank you, Ankit, and welcome to 104th episode of AAA weekly webinar series. As we say that the commitment is commitment, and this commitment that we are trying to complete when we are not in India, and it is a kind of vacation that we are playing golf, and in between the golf game, we are now trying to do this, although it is late 2-3 minutes because of the running here and there and getting the internet connection. So the subject today that we are going to discuss is the reverse insolvency. It is basically on demand because a lot of people, they asked for the complete research on the reverse insolvency or reverse CIRP. It was in fact started by Honorable Justice 𝐓𝐸𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬 passed in 2020, and finally it has already been upheld by Honorable Supreme Court. So the basic concept of the CIRP is that that it is essentially for real estate companies, and where the promoter can come forward. Promoter can propose to the bench that he would be able to contribute funds and he would be able to complete the project under the reasonable time. And then in that case, there are two conditions normally promoter puts. One, that I will bring funds, I will complete the project, I will also take the contribution from the home buyers as it is due from them towards their allotment. And the only thing is that whatever I am funding, that should be considered as a third party finance, and that should be considered as an interim finance. So with these kind of conditions, it was an experiment done by Justice 𝐓𝐸𝐻𝐬, and it was called by them like reverse CIRP or reverse insolvency. Primarily, it is in the interest of the home buyers, because see, the cases of home buyers were not getting resolved because of various disputes, because of the funding is not coming from banks, and therefore this was the concept which was experimented. And like the primary conditions are that the company will get moratorium from the various cases under RERA. Also, company will get moratorium under Consumer Protection Act, and the Section 14 moratorium would be applicable. This is where the protection is available to the company. If the protection is available to the company, the funds are being monitored by RP along with the committee of creditors, in case the committee of creditors is also constituted. So this kind of remedy where there is a protection from RERA, protection from Consumer Protection Act, protection from any other kind of litigation, and protection from SIRP, protection from other enforcement of security interest, all this done. Therefore, while all the protections are available during moratorium, the RP and the COC can actually work together along with the promoters, and the construction can be completed and the units can be handed over to them. So the first case, as I said, was in the name of Flat Buyers Association, Winter Hill versus Umang Realtek Private Limited. Umang Realtek Private Limited was the corporate debtor, and it was a company where the CIRP was initiated, and by that time it had already happened that the allottees will take precedence over the secured creditors also and over the unsecured financial creditors also. And it was also in this case held that the allottees even will opt, rather they will opt to shift to those towers or those areas which are on advanced stage of construction. However, the refund was not allowed in this case. The only thing was allowed was the possession of the property. That was the only thing which was allowed. So this was the kind of option. However, the third-party buyers were allowed. The allottees, they were allowed that you can even sell to third parties, and they can enter into an agreement with the promoters with their sweet will. This is what is the overall structure of the reverse insolvency. And in fact, another case which had actually gone to Honorable Supreme Court, that is the case which is Anand Murthy versus Sony Infratech Private Limited. Anand Murthy versus Sony Infratech Private Limited. That was actually the Supreme Court, in fact, upheld that part, and the Supreme Court says that it is, in fact, beneficial. The Supreme Court, in fact, says that it is beneficial for the real estate projects. It actually allows the timely completion. It is in the interest of home buyers, and the promoters also have incentive to complete the unfinished projects. And therefore, the Supreme Court also observed that let us understand the objectives of proposing for reverse CIRP. The Supreme Court said that first of all, the commercial wisdom of the home buyers, which are the committee of creditors, that actually will be superior to any other option. So the reverse insolvency also can happen only with the kind of commercial wisdom of home buyers with their will. So this is the need of the hour, that in case of real estate cases, the cases can be tried under reverse insolvency. The financial backing is also possible. Financial backing is also possible. In case the promoters are not having funds, they can actually bring another third party who is ready to bring the financing. So in one of the cases, even the JM Financial came forward and allowed the financing, contributed the financing as a third party, and that financing was considered as an interim finance, was considered as CIRP cost. So this is where I'm trying to analyze. This is, in fact, very clearly, the various courts have actually held that when we talk about the reverse CIRP, in the reverse CIRP, one, that the promoters are permitted to participate into the construction, promoters are permitted to contribute, promoters are permitted to resolve the case, whereas in CIRP, unless the company is MSME, the promoters are prohibited from the submission of a resolution plan. This reverse CIRP is also a kind of resolution plan which actually would be implemented within reasonable time under the supervision of the Committee of Creditors and the RP. Now, in this case, however, in the case of reverse CIRP, the entire cost of CIRP, the entire CIRP cost would be met by the promoters. The entire CIRP cost would be met by the promoters. However, in the case of CIRP, in the case of normally it is to be met by the corporate debtor. So even this reverse insolvency is less time consuming. So when it is said that it is less time consuming, I'm only trying to say one thing. If a project is still to complete and the completion will take more than 2 years, more than 1 year, then it is very difficult for any court, for any bench to agree for reverse insolvency. Because that means that in case the NCLT agrees for reverse insolvency and the construction period is, say, more than 1 year and more than 1.5 years or 2 years, then in that case, it would mean that the CIRP period is extended beyond 330 days, which is the maximum period under the CIRP. So in case any promoter proposes that I will complete the project in 1 year or even more than 1 year, then the NCLT will have to think about whether the NCLT will extend the CIRP period beyond 330 days or not. So this is also one of the very important condition, that the project should be near completion, and there should be a fair estimate of the actual cost of construction which is still pending, and that actual cost of construction is, there is a complete fund flow available, including the fund which is supposed to be contributed by the home buyers on completion of the construction. So this is where the completion of the reverse CIRP happens when the units are handed over to the allottees. Then RP will give a certificate. This is the completion certificate. Then that completion certificate will go to the adjudicating authority, and adjudicating authority will finally kind of close the CIRP, and the company will happily go to the promoters, happy promoters, because see, the home buyers are happy, the promoters are happy, and in case any funding has actually been raised from third party, that also is happy. So therefore, the kind of however, in some of the cases, the court have also taken a kind of undertaking from the promoters that they will not impose any price escalation on the allottees. So that also has actually been done by the various in some of the cases. I also have seen a couple of cases where the one is that the reverse CIRP can be applied by promoters, and also in some cases the reverse CIRP is applied by the home buyers. The home buyers can also apply for the reverse CIRP. That means that the home buyers can collectively commence the construction. Collectively, they can contribute, and they can also raise some funding from outside, and they can complete the project. That also is possible. Now, the reverse CIRP also has some kind of criticism of kind of this structure, and the courts have in fact clarified that if the financial creditor fails to contribute sufficient funds, then the company cannot continue as a going concern, and therefore the CIRP would actually get disturbed. CIRP would get disturbed. Also there is a conflict in case of committee of creditors, which are a kind of mix of allottees and secured financial creditors and unsecured financial creditors. In all those cases, the committee would actually get divided. The committee as a whole would not be interested in reverse CIRP, because in reverse CIRP, allottees will get gain more than the secured financial creditors and unsecured financial creditors. Even some people have criticized that this reverse CIRP is not even 29A compliant, like especially in those companies where the company is not MSME, especially in the case of Supertech. In case of Supertech, in fact, 2 orders were passed. It was the project kind of insolvency and also the reverse insolvency. This was the 2 kind of possibilities were seen. And also, when we are saying that it is Section 14 is applicable, RERA can't do anything as per the present law. Consumer Court is not doing anything. So the company is actually getting gained out of this process. The promoters are getting gained out of this process. So therefore, there is a criticism that this particular reverse insolvency is little biased towards the promoters, and where in the Umang reality also even this was a project-wise CIRP and the reverse CIRP, both were ordered in Umang reality, which is the Winter Hill cases. Now, there are practical issues that we have seen in various judgments where some observations have been made by court that yes, there are some practical difficulties. More practical difficulties in case the company is having multiple projects and the reverse insolvency is applied only for one project and it is a project-wise insolvency. So therefore, it is a difficult question to answer, like which operational creditor supplied what kind of material and it was for which project. That is something which is prone to manipulations. So if one project is under moratorium, normally the promoters are taking benefit for the entire company as far as the moratorium is concerned. The promoters are taking benefit on the other projects also because this moratorium is there. So that is something the operational control, whether the board of directors will have powers, whether the RP will have power, whether the committee of creditors will have power, how much construction cost would be incurred, whether there is a project management consultant or not, whether there is a tendering system for the item-wise tendering system or not. Because there may be a possibility that because in the reverse insolvency, the courts have said that during the reverse insolvency, even the RP and the committee of creditors can sell unsold inventory. So there is a possibility that because of the connivance, the promoters or the RP or the committee of creditors, they can even siphon off more money while they are selling the unsold inventory. And even the RERA is also not happy with this kind of reverse insolvency, because this is also because the RERA needs compliances. And there are circumstances that in the reverse insolvency, the promoters and the RP and the COC is saying that we are working under the directions of NCLT. We are working under the directions of NCLT. NCLT has asked us to continue the construction. NCLT has given an order to sell the unsold inventory. NCLT has given us the direction to take balance money from the allottee. NCLT has given us the instruction to take third-party financing. So therefore, we are not even liable to compliances under RERA, like the 70% of the amount can be withdrawn from the escrow account. That complies. All registration has to be renewed. That complies. So there is a criticism also to this the kind of experiment and the bifurcation of creditors. Also, as I said, it's also kind of very, very difficult bifurcation of creditors. And see, like, while we are talking about reverse insolvency, NCLAT has in fact said and observed that it has to be a very, very transparent and strict mechanism to ensure that the projects are totally at arm's length. There is a separate accounting for the projects. There is a like one project is under CIRP, and that has to be kept clearly a separate kind of entity. So therefore, these are various issues which are kind of these are challenges also. Even some responsibilities on the RP. Like if we consider that the RP is the expert in real estate, if we really consider that the RP has all the accounting for all the material purchased, RP has all the kind of pricing in the market. So that is also something which is not possible, because all the existing employees of the company will work, and the existing employees of the company will be more loyal to promoters rather than RP. The existing employees will purchase, will make purchases, will make the payment to the contractors, and the RP will only have to just take approval from the COC and do this job. And the COC also would not have any in-depth knowledge of the construction. So the only issue is that the completion time is something has to be specified by the court. And if the project is not completed within that time, I still feel that another application will be filed by the RP or by the COC or by the promoters, and the court will see that yes, about 70% work has been done, so let the 30% also be done. So this kind of stretching the CIRP beyond a kind of, but still, all said and done, there are benefits and there are various like challenges also. So Ankit, like now we are coming to the kind of judgments that we have by specifically, like in what judgment, what happened. If there are questions, then can we take questions at this moment?
Yes, so there are a few questions. So one question is that when home buyers have paid only 50% of the cost, whether they should contribute in reverse CIRP. So I think the idea is that they should not be asked to contribute additionally over and above what they are already committed to. If they've already paid 50%, then they are ideally supposed to pay the remaining 50%, because that is the cost that they have kind of agreed to pay for the flats. Then we have a question from Mr. Hari Prasad. He says that reverse CRP appears to be suitable to real estate or home buyers. Can there be any customized reverse CRP which can be designed for any other industry? Has
No, I
that
was also
kind of
thinking, I was also thinking like as a concept, it is possible,
hmm,
but like in other kind of industries, if there is a default and the promoters come forward and say that yes, we are trying to resolve this, then the financial creditors will say, okay, you get the third party finance, and then we will go for 12A. Why reverse insolvency? Because in that other cases, it is a default. Either you pay or you come through resolution plan.
so there
You
will
see
be
the
alternative ways like OTS, like
yeah,
12A, like other things will follow in. So they will not really kind of have an NCLT order with them, which kind of talks about something like a reverse CRP in your opinion. Okay. So then we have a question that what mode of treatment of the profit or loss arising on the completion of reverse CRP? So the treatment is as per the books of
this will go
accounts.
to promoters.
This
Because see,
will
the
go.
company will go to the promoters. Whatever profit will be made in this during this period, this is CIRP will be closed.
Hmm.
Once the CIRP is closed, the company will go to promoters.
The board of directors will also will also get revived because the
Yes,
company, the CRP will finish. So that's also
yes.
taken care of. Uh, the stakeholders who are like the stakeholders, the creditors, the home buyers may or may not get a right on the profit depending on what is the agreement between them, right? So there can be a
They will not get
situation.
any right on the profit because that's what is the reverse insolvency. The promoters are coming forward, they are contributing or they are bringing third parties to contribute for the funding. And
Hmm,
whatever profits would be there, whatever unsold inventory would be there, that will go to promoters only.
right.
That is very clear in this among reality that whatever unsold inventory is there after the CIRP is closed, after the allottees are given the possession, that will go to promoters only.
Mr. Maheshwari asking who will bear the CRP cost. So ideally, the CRP
Promoters.
cost is paid by the promoters, and that is
Yes.
taken care of as a cost. And in tripartite agreement with financiers, what and both have who have contributed to the project, what will be their position? So those who have given money to the or who are financial lenders to the company, their loan will remain, and that needs to be settled by
Okay,
the
that's an
promoters
interim finance.
separately.
Interim
Yeah,
finance
yeah.
will carry some interest. Whatever interest will be there, they will get their interest. And they will also get the priority because that's an interim finance.
So basically, that's the case. Then whether secured financial creditors will have a haircut as reverse CRP benefits only home buyers. What about OC payments, FC payments? That's a question
No,
that is coming up.
that will not happen here. No haircut to operational creditors, no haircut to unsecured financial creditors, no haircut to the
This is
secured
technically
financial
possible
creditors.
only where the project is almost completely viable or where the promoter has struck side deals to kind of waive off certain liabilities which otherwise might be troubling him. So
No
I think
waiver of
that's
structuring liabilities
yeah,
because this will be something which is the CRP will be closed as if it is just like it is akin to 12A. It is akin to 12A. In 12A also no relief, no concessions. It is only the simply the company will go back to promoters after the handover of the units to the allottees.
right. So home buyers, if they have 15% share in the COC, can they oppose liquidation of the CD? Can they request giving more chance to RP to invite and issue Form Gs? So I think with the 15% COC, if the COC has a different mindset, then it will clearly be a voting system. So the voting may not help. And I think recently also there was a case that talked about this whole idea that if home buyers are having a minority share, then they cannot kind of say that their interest needs to be taken care of. The COC will function as a whole body only. So I think that's the case here.
Yeah.
So, if in a project units were completed, i.e., at an advanced stage and balance at initial stage, how to match the situation? So, in any project, there can always be this discrepancy that certain units are almost complete, or certain towers are almost complete, certain towers are not complete. So there, if there is any unsold inventory which is there, we normally, I think, there is a practical system to shift those people to the ones where the project is almost completed. All that goes on. So maybe that kind of a system can be followed. Back to you. So I think we've taken care of all the good questions.
So basically, what is the anxiety amongst all our audience? Like what kind of projects actually can be good for reverse insolvency? One, it should be primarily the COC of the home buyers. Second, the project should be near completion. Three, there should be a funding arrangement with the promoter or the promoter can bring third-party funding. Four, the total project completion should not be more than 330 days because that's what actually, otherwise at the outset, the NCLT is allowing the CIRP, which is much more than the stipulated 330 days. So these are some conditions where the uh, these are some conditions which are most suitable for the reverse CIRP or reverse insolvency. Now, like coming to the specific judgments, which is the Flat Buyers Association, Winter Hill versus Among Realtek Private Limited. This was given by Justice S.J. Mukhopadhyay and Justice Bansilal Bhatt, and it was again upheld. It was again upheld in the case of ARCIL, a asset reconstruction company, India Limited versus Dagpon India Private Limited. Dagpon India Private Limited is also handled by a designated partner of AAA Insolvency. So this case actually went to Honorable Supreme Court, and Supreme Court upheld this the concept of reverse insolvency first time in the case of Dagpon India Private Limited in August 2020, and in a later case it was also upheld in another case. I will just let you know. So in this case of Umang Realtek Private Limited, it's a real estate company, and the CIRP was not getting resolved. There was a reluctance to approve any kind of plan, and therefore the Uppal Housing Private Limited, who is one of the promoters of this company, Umang Realtek Private Limited, agreed to act as a lender, which is a financial creditor outside the CIRP, along with the cooperation from JM Financial Credit Solutions Limited, and that was the first thing that they tried. Since the resolution plan was not coming, resolution plan was not suitable for approval, Uppal Housing Private Limited came forward with the help of JM Financial Credit Solutions Limited. The third-party funding was created, and an application was submitted to and directly it had come from the NCLAT. So in this case, the prerequisites, which was discussed by Justice S.J. Mukhopadhyay, it was discussed like there would be an agreement between the promoters and the allottee to let the promoter act as a financial lender of the project. Second, the promoters to remain outside CIRP, but to ensure that the allottee get possession during CIRP without any third-party intervention. Promoter to give a time frame to the bench for the project completion, and even for common area. Promoter also supposed to provide the amount which is due from allottee. I mean, the promoter is allowed to take amount which is due from allottees. And in case the default is committed by them, the promoter can take action as per the original builder-buyer agreement. Also, the original builder-buyer agreement will be honored by the builder as well as by the allottees. Now, all this amount which is raised, that actually will be utilized for the construction, for the completion of the project. And this will be a separate bank account was also stipulated in this case. And even the counter signatures of the RP was also mentioned in that judgment. The counter signatures of the RP, that was also mentioned along with the signatures of the promoter. The financial institution, banks, they were also paid out of the sale of unsold inventory. They were also paid out of the unsold inventory. So the allottees were also making payment of their dues. Allottees were allowed to form RWA. Even the resolution cost, CIRP cost, was also to be borne by the promoters. Unsold flat, unsold units were allowed to be transferred, allowed to be sold, and the money was allowed to be realized. So this is what was happened in the first time, and it was a very, very detailed kind of judgment. And the appellate tribunal, the Justice Mukhopadhyay, in fact, tried this as a kind of where, in fact, in the judgment itself, the order, in fact, tried to explain what is the reverse insolvency and what are the benefits of reverse insolvency. As a concept, it came in that particular order. And as I said, everything like the moratorium will continue, and the directions actually which was given, like the allottees seeking refund cannot be granted. They can request the IRP or the promoter to find a third party who can buy their property in case they don't have funds to contribute. But they cannot ask the company to refund their money. And the promoters are also directed that they will cooperate with the IRP, they will cooperate with the COC, and they will create a very, very kind of transparent system of construction. All this was provided in this order. Specific timelines has to be there, and upon completion, the CIRP will be closed after obtaining the approval from the adjudicating authority. That was the final the observation. Unsold apartment, unsold units, any other asset which are remaining in the company, that will go to promoters. That will go to promoters because the CIRP is closed. It is not a resolution plan by any other party. It is this reverse the reverse insolvency is just like a Section 12A kind of withdrawal. So this is the judgment, which is the original judgment. Then is the another judgment which we are talking about today is the Pradeep Kumar Chaudhary versus Dagcon India Private Limited. The date of the judgment is 4th March 2020, and this has also come from Justice 𝐓𝐨𝐻𝐬𝐬𝐜𝐝 and Justice Vanchilal Bhatt. This particular judgment, finally, when this order came in March 20, in August, in August 20, the Supreme Court has also upheld this concept of reverse insolvency in this case of Dagcon India Private Limited. And in this particular case, in fact, the RP moved an appeal. RP moved an appeal before with the grievance that due to failure on the part of the directors and other officers of the CD in handling over the record, RP is not in a position to give possession of the flats or apartments or shops which have already been completed. So it was actually submitted by the RP that the reverse CIRP may not be applicable in this present case, as the CD is not a real estate company. In fact, the CD had by that time the CD had already constructed that particular building. However, some of the allottees were not handed over the possession. Because since we are involved in this case, so it was a case where the building had already constructed, but the possession was not being given to by the promoter to the allottees. So in this particular case, finally, ANCLAT also said, that this reverse CIRP apply even if the CD is in the business of selling the flat, even if the construction is not pending, the reverse CIRP would be applicable. In Dagcon India Private Limited, the reverse CIRP was available, it was applicable only while there was no construction pending. Then coming to the other direction, in this particular case, Justice Mukhopadhyay directed RP to identify the allotted and unallotted units, ensuring the CD remains operational. If the flats are completed, the RP must proceed with the handover. RP must seek assistance from the promoters. So that was finally it was held by ANCLAT, and it was upheld by Honorable Supreme Court. Now, the third judgment that I would like to take is the Anand Murthy versus Sony Infratech Private Limited. The corporate debtor in this case is also Sony Infratech Private Limited, and this was the judgment which was in 27th of April 2022 from Honorable Supreme Court of India. From Honorable Supreme Court of India, and in this particular case, Justice L. Nageshwara Rao and Justice Bhushan Ramkrishna Govai was the author of this judgment. And again, in this particular case, the Honorable Supreme Court has held, because this case, the ANCLAT again passed the order, because it was basically modification application was rejected, filed by the suspended director. ANCLAT observed that in meantime, if the settlement takes place between the parties for completion of the housing project, the same can be filed under Section 12A of the IBC. So in this particular case, ANCLAT for the first time said that the reverse insolvency is not suitable in this case. The application was submitted that there is a settlement between the allottees and the promoters. As per the settlement, the promoter will complete and hand over. The NCLAT said that this is not a case of reverse insolvency. This is a case where you actually can come up with Section 12A, withdrawal application. And therefore, NCLAT directed the RP to hold the meeting of the COC within 10 days from the date of the order and decide the future course of action about a resolution for completion of the CIRP or 12A voting. Now, then this was like after some time was passed, NCLAT in fact asked the RP to constitute COC meeting. But when this case went to Honorable Supreme Court, then let us understand what are the discussions during the, what were the voices from the courtroom, what were the discussions in the courtroom. So first of all, the court acknowledged, the Honorable Supreme Court acknowledged the undertaking filed by the promoter agreeing to return money with 6% interest. So this was part of the settlement, that the promoters agreed that they would be returning the money at the rate of 6 with interest at 6% per annum. The promoters also committed that the project will be completed within the timeline, and no escalation of the flat cost was also proposed. No additional money would be taken from the allottees. That was also there. The promoters also proposed that a monitoring committee consisting of representatives of the both home buyers and the management side would be overseeing the entire process. The court highlights that the possibility of higher cost for home buyers under CIRP, because the court said that in case this home buyer goes to CIRP, there may be an additional cost, because somebody who will come from outside may even have the desire to make more profit out of it. Therefore, after all these observations, the Honorable Supreme Court said that the reverse CIRP is allowed in this case. RP was directed to submit quarterly report to NCLAT regarding the completion of the project. So this is something which is now, we have discussed three cases of the three prime cases of the reverse insolvency: Sony Infratech, Umang Realty, and also in the Sony Infratech, Umang Realty, and one in a scenario with the DAGPON. So all these three cases, in fact, have seen the Supreme Court observations, and it has completely held that the Supreme Court is also in favor of the reverse insolvency. So there are other judgments from NCLAT, and one judgment is Rajesh Goel versus Babita Gupta, and this judgment is in 5th of February 2020 from NCLAT, again from this from Justice 𝐝𝐤𝐬𝐬𝐜𝐝 and Justice Venugopal. And in this case, again, the promoter moved an application that in fact, allottees moved an application under Section 7. The promoter moved an application that this application should be rejected because the allottees have also defaulted. Allottees have also defaulted. And the promoter, in fact, submitted that 9 towers of the project are at the verge of completion. At the verge of completion, 9 towers. So in this case also, the NCLAT said that the RP should collate the claim, there should be a voting share, and there should be a financial creditor and as an outsider, and this should actually allow the project to complete. There should be a cooperation from the RP, and the promoter also said that the financial creditor will contribute. So the decision in this case was also something which is similar to the other decisions. The NCLT ordered cooperation from promoter, direction to disburse funds for the completion of project as an external creditor. Specified time limits were also given in the order. Some of the allottees who were asking refund, they were also told that they should be given refund within a stipulated period, along with the payment to financial institutions. So all these processes will be done within a specified period. RP was also empowered to sell unsold flats, and the proceeds also would be utilized for the completion of the project. Resolution cost will be borne by the company or the promoter, and even the process for the sale of unsold inventory was also defined, that there will be a tripartite agreement between the purchaser, IRP, and the promoter. and the proceeds from the sale will be used only for the completion of the project, pay back to the financial institution. So this was also a very, very clear order of ANCLAD, where the after giving the justification, after giving the Supreme Court orders, the concept was again kind of accepted very clearly. Now, coming to another judgment, which is from ANCLAD by the name of Vijay Kumar Pasricha versus Manish Kumar Gupta. And this judgment was given by Justice Rakesh Kumar Jain and versus Naresh Salecha. So this was the judgment on 24th of March 2023. And again, the effect of moratorium was kind of challenged in this case, and the effect of it was actually said that the RP or the promoters are extending the moratorium to other projects also. They are extending the moratorium to the entire company. The moratorium should be restricted to the only to the project like Winter Hill. This was a case of Umang Realtek, and it was said that the project may be restricted. It should be restricted only to the Winter Hill, the moratorium, and the decision of the ANCLAD was very clear that Section 14 is applicable, and it is only on the moratorium on the CIRP. Immediately, it is aimed at protection of the assets and liabilities of the corporate debtor. However, the moratorium was confined to the scope of the reverse CIRP to the Winter Hill 77 project, ensuring that it does not impact other projects of the corporate debtor. So since there is no provision in the law regarding reverse insolvency, there is no regulation, there is no section regarding reverse insolvency. So therefore, it was supposed to be innovative, and in that process, everyone is supposed to kind of cooperate, and the moratorium would only be restricted to confined to the project, that is Winter Hill 77 project. So this was the clarification provided by ANCLAD that the moratorium is only restricted to that particular project. Then we have another judgment in the case of Supertech, and that is a judgment which is Ram Kishore Arora, the suspended director of Supertech Limited versus Union Bank of India, and the corporate debtor in this case is Supertech Limited. And the ANCLAD decided on 10th June 2022, and this order was by Justice Ashok Bhushan and Mr. Naresh Salecha. And again, it was said that the CIRP is initiated against this company Supertech, and the real estate company, it is only by one bank, and that bank had only invested in one project, that is 𝐝𝐸 2. So that bank who has filed Section 7 application has only funded to the one project, which is 𝐝𝐸 2. And the promoters had actually filed an appeal against the CIRP order. The promoters have already said that the 20 projects of the company were ongoing projects, and were substantial units were in fact sold. And the large number of home buyers are there in this company. And in case we extend this insolvency to all the projects, it will be a chaos. And since it should be confined to 𝐝𝐸 2 only, that was the application from the promoters. And it was also let us see the project. The promoters also, ANCLAD also decided that ANCLAD, after looking into this case, the ANCLAD decided that the promoters are ready to extend all corporations and all staff and the employees to IRP. We see no reasons for not to direct the IRP to proceed with construction of all projects under overall supervision and control of the IRP. The COC for only 𝐝𝐸 2 project was constituted, and the IRP was directed to continue the project as a going concern by taking assistance from the employees, management, and workmen. All other projects of the company, apart from 𝐝𝐸 2 project, shall be kept as an ongoing project. The construction of all other projects shall continue with overall supervision of the IRP with the assistance of the ex-management. So that means that the other project allottees are not supposed to file their claim. RP was made responsible to continue with the construction. Promoters were told to cooperate. all the existing employees were told to cooperate, and the promoters will infuse funds in case it is required. Now, when this application was made originally for the insolvency of Supertech Limited, the applications were made by one Union Bank of India and other it was India Bull Asset Reconstruction Company. So these are the two applicants in two different applications. So then the NCLT in fact passed the order of insolvency of Supertech Limited under Section 7. Now, out of this, India Bull's Asset Reconstruction Company filed an appeal against the order of NCLAT, where the NCLAT has said that the RP would be responsible for overall company. However, the CIRP is restricted only to the Eco Village 2 project. So in this case, this appeal was filed before the Honorable Supreme Court, and the Honorable Supreme Court, in fact, decided on May 11, 2023, and the Supreme Court, in fact, said although there is no provision regarding reverse insolvency in the law. So the contentions by the parties like Union Bank of India, India Bulls, they were saying that there is no such provision of reverse insolvency. There is no power vested with NCLAT to issue directions for insolvency, which is reverse insolvency. In the absence of any power with NCLAT or NCLT, how this order of Supertech is passed. And also Supertech is not an MSME. So these promoters participating into the resolution of the company is also not really good, and it is not compliant to Section 29A. Now, the parties were saying that the financial creditors are actually biased adversely in the case of reverse insolvency. Financial creditors would not be considered making payment because mostly the focus would be on the construction completion, and the promoters will focus on the construction and they would not pay to financial creditors. And IRP also opposed any interference with the directions issued by the NCLT. So the home buyers of Eco Village, they were also kind of okay, that they are okay with the reverse insolvency. So therefore, when the RP was in favor, when the home Eco Village project 2 was favorable, the Supreme Court kind of ignored India Bulls and Union Bank of India. So Supreme Court very reluctantly, I could say, held that if at present stage, what we are talking about the present stage, because the first order was passed in 22, and now this order is passed in this particular order of the Honorable Supreme Court is passed in October 23. Now the Supreme Court said that the COC is already constituted for the corporate debtor as a whole in the displacements of the directions of, so it is likely to affect the ongoing projects in case we disturb. And the home buyers, while throwing every project into the state of uncertainty, they would actually be come under some kind of hardship. Further, it was held that the role of the erstwhile management should be limited to the extent no new rights would be created by them. So the Supreme Court said that the greater convenience is likely to be caused, greater inconvenience is likely to be caused by passing an interim order of kind of relief or constitution of COC. Supreme Court also declined to alter the directions of NCLAT, which was given on 10th of June 2022. See, in this case, the Supreme Court also took the help of this legal concept of obiter dicta. Obiter dicta, and they encountered the aspect of the nature of interim relief arrangement until the disposal of these appeals. So it was kind of considered that it will be causing more inconvenience. So for the purpose of general convenience, the Supreme Court agreed for the project insolvency and reverse insolvency of Supertech. Now we have another judgment from Ajay Singhal versus Gaurav Katiyar. Gaurav Katiyar is IRP, and this is again an NCLAT judgment, and this judgment is very, very latest. 18th of March 2024. 18th March 2024 by Justice Rakesh Kumar Jain and Mr. Naresh Salecha and Mr. Induvar Pandey. Now, in this case, the promoters have preferred an appeal, and during the pendency of the appeal, the product, the allotee, and the secured to vote for the company. So this was also a kind of project which was the prayer was allowed. The prayer was allowed, and the creditor were directed to vote. Upon voting, the promoter was directed to complete the project in terms of the plan stipulated in the and the affidavit was submitted by them. So therefore, the reverse insolvency was carried under the aegis of IRP. And finally, we have another judgment, which is Dharmesh S. Jain versus Sarai Equipment Finance Limited. And in this particular case, the corporate debtor is Nirmal Lifestyle Kalyan Private Limited. This judgment is again January 23. And in this particular judgment, again, the CIRP was initiated. Appeal was preferred against CIRP by the promoters and allottees. The promoters challenged the CIRP order on the ground that the default basis with CIRP had commenced was imaginary default. Promoter contended that the CIRP be confined only to the project where financial creditors are concerned. The present is a case where reverse insolvency process as recognized by this tribunal should be resorted and reverse CIRP be adopted so that all the projects be not included. Now, in this case, the NCLAT said that the order initiating CIRP is upheld. COC may deliberate on ways and means to complete the unfinished project, either by obtaining interim finances or by inviting resolution plans. It shall be open for the COC to invite resolution plan or project-wise building-wise, project-wise, individually or separately or jointly as may be found feasible and practical after looking into the overall facts. The suspended management and the employee of the corporate debtor may extend their cooperation to IRP, RP in completion of the project. So this is where clearly the reverse insolvency was not started. Reverse insolvency was not directed by NCLAT clearly. However, the responsibility was shifted to COC. They may feel like inviting project-wise insolvency. They may invite resolution plans building-wise. They may invite resolution plans individually, and the suspended management to extend the cooperation. So this was the case. It was where it was denied. In fact, the reverse insolvency was denied in this case, and the COC was kind of empowered to have project-wise resolution plan. So in another case, which is AU Small Finance Bank Limited versus Coral Infra Gold Private Limited, that is NCLT Jaipur order, and this is in this case also the CD was admitted to CIRP. So IRP preferred an application before NCLT seeking clarification. So there were clarification which was required, and the one clarification was that what is the kind of obligation of the RP in the case of reverse insolvency, whether the valuation should be conducted or not. And in this case, the NCLT held that no valuation is required because the basic objective of the valuation is to provide that valuation to the committee of creditors, and that will help the committee of creditors in approving the resolution plans. So the valuation is not required to be conducted. Also, the RP was seeking a kind of direction whether the RP is supposed to release the information memorandum or not. So that was also held by the NCLT, that the RP is also not supposed to prepare information memorandum as the same is not required. The expression of interest is not being released. The public is not invited for submission of resolution plans. So therefore, no information memorandum is required in these cases. So Ankit, this is all we can actually say, although there is another judgment which is N. Kumar, and that is in the case of Sheltrex Developers Private Limited, and that is versus Tata Capital Housing Private Limited. That's again NCLT Chennai bench judgment in the April 22. And again, Now in every case the promoters are asking for reverse insolvency, project insolvency. So there is everyone is trying to take the shelter of Winter Hill 77 Gurgaon project, and therefore in this case also, since uh, in this case the court, in fact the NCLT Chennai said that this Umang Realtors Realtech Private Limited case cannot be just applied everywhere. It should be with special circumstances where this kind of reverse insolvency can be directed or ordered. And that should be, as I said, the various conditions. And those conditions are still kind of very, very important. One, that so this case, in fact, it was rejected. So in case we have to conclude, there must be some financial backing. It should have the support of home buyers, and it should also have the time, which is the minimum time, and RP also should be ready to kind of cooperate and complete the project. There should be an agreement between the promoters and the allottees. The CIRP cost would be paid by the CD and the promoters. The possession will be given, refund would not be given. There should not be a very large time period for this. All this has to be there. Then only the reverse insolvency would be ordered. So this is all from our side, Ankit. In case there is a question, we can take up the questions. You are mute.
Very sorry. I'm saying that I've taken care of we've taken care of all the questions, but one question that remains is that what are the duties of the IRP RP in case of reverse CIRP vis-a-vis CRP? And also, is there any timeline in which the promoters and the RP they kind of work together where their roles are distributed between themselves? So these I think are two questions that we can deal with.
No, you see, the RP is fully responsible. Rather, RP's responsibility would be more than the CIRP, because the RP would be keeping the company as a going concern. RP will complete the construction along with the promoters. All the existing employees of the company will work, and RP will also kind of pass all necessary resolutions for third-party financing. RP will be authorized to sell the unsold inventory. RP will be able to kind of shift some of the flat owners to those towers where some construction is at advanced stage. RP also can allow some of the refunds if the promoters agree. RP actually will try to make a very, very transparent and the mechanism for completion of the construction, usage of the finance. RP will have to make check. RP will have to sign all checks. RP will have to approve all the bills. So in case later on, if it is found that the RP was signing checks and those checks, the material had never come, or that those were overpriced, then RP in any case has to be kind of give some basis on which he had been taking decisions, where he had been paying to the contractor, he had been paying to the suppliers, he had been also selling the flats. So the RP's responsibility is additional, and it is much more. So this is where, and the timeline which I am saying that, like according to my understanding, no promoter can say that give me an opportunity, I will hand over the flats within 2 years. That means that he's immediately he's saying that he will continue with the CIRP for 2 years. Otherwise, which is provided in the law, is 330 days. So this is all we can say regarding the duties and the timeline.
Right. So I think we've taken care of this. So I think that's about it.
There is only one hand which is risen, is a Nitin Panchal.
I'll just allow him to speak and see in case he has something to say. Nitinji, if you would want to unmute yourself and
Yeah, I have typed the question.
So he's typed the question. He said that he's typed the question.
So construction has to be completed as per CRP timelines. That's the question.
Yeah, construction has to be completed as per CIRP timelines, because see, I don't think the court will actually permit a 2 years or 3 years time for completion of the construction and continuation of the CIRP and continuation of the moratorium. It is only and only possible in those cases where the construction is at last stage, the funds required are minimum, the funds required are arranged, and the court feels that yes, the construction can be completed, the possession can be handed over, and that process would be shorter than the CIRP process. If that process is larger than the CIRP process, then no court will actually permit CIRP, reverse CIRP. The court must be convinced that the reverse CIRP would be shorter than the normal CIRP.
Okay, thank you so much.
Yes. So it is wonderful. I think Sivaraman is also trying to ask a question. Sivaraman is the partner, designated partner of AAA Insolvency.
Sivaramanji, maybe you can unmute and say so.
Good morning to you, both of you, first of all. First thing is, with regard to the recent judgment of Noida Authority, Greater Noida Authority by Supreme Court, taking them as secured creditor, will it affect the reverse CIRP process in any of the cases?
Certainly, it will impact the reverse insolvency cases, because in case there are secured financial creditors and their interest has not been kept in the original directions given by ANCLAT, and their interest was not really protected. So therefore, they will also object to the reverse insolvency. They will object that the project is completed, the units are handed over, and there is no provision for our payment as far as the land is concerned. So they definitely will object. And in case there are any such cases, probably Noida Authority, Greater Noida Authority, after that case of Greater Noida Industrial Development Authority versus Prabhjeet Singh Soni, after that case, they might even file appeals saying that their rights are biased and they are impacted. They have a right as a secured operational creditor, and in this particular order of reverse insolvency, the rights of secured operational creditors are not dealt with. So that may happen.
Fine, sir. Thank you, sir.
I think we can close it. Thank you very much. And as we always say, that this is our way of learning. And thank you very much. We'll see you next week,
Thank you,
Saturday,
everyone.
11 a.m.
Thank you.
Thank you.